Hi, good afternoon. We're super excited that you are here today for our virtual seminar to talk about virtual hearings amid the COVID crisis. I thought it would be a good idea to introduce you to who all is participating. We have a really interesting group participating from local governments, from various lawyers around the state of Florida, developers, as well as consultants, including engineers and planners, and also local active community activists. So we're excited that you've all joined us today. You may be wondering, why this seminar? I think the fact that there's over 200 people that are actually attending today shows that this is a real issue for all of us in our community. We wanted at Stearns Weaver to make sure that we emphasize how important we think it is that if this current situation drags on much longer, or if there's a resurgence sometime in the fall, that every community has a plan B for virtual hearings in place. Just briefly, we want to talk about the agenda that we're going to go over today so you know what to expect. We're going to give you a background on the types of local governmental decisions. Those of you in the local government already know this information, but everyone else, it's a good refresher. We want to go over concerns that we've heard raised by local governments related to putting on virtual hearings, particularly in the quasi-judicial realm. We want to briefly touch on property rights in the law and how virtual hearings may affect those property rights. And finally, and hopefully the most interesting and interactive part of this webinar will be to talk about best practices for appearing before a local governmental body during a virtual hearing, but also best practices for local governments, share ideas that we have found around the state of Florida. Quick housekeeping matter for all of you that are participating. We really want this to be interactive. So if you look in the upper right-hand corner, there's a little box that pops out. You can at any time during this webinar type in questions that you have, and we will answer those. We don't plan to speak more than about 30 minutes, and so we want to use the rest of the time to answer questions that come from all of you. So without further ado, I'll just introduce those that are going to be speaking today. I'm Elise Batzel. I'm a shareholder at Stearns Weaver. I've been practicing in the area of land use and real estate for almost 25 years now in the Tampa Bay area primarily, but I have appeared in over 42 jurisdictions throughout the state of Florida. So I've touched a lot of the different jurisdictions, and I'm excited to be a part of this. Jake, do you want to introduce yourself?
Sure, thanks Elise. My name is Jake Kramer. I'm a land use attorney in the Tampa office of Stearns Weaver Miller. And my background is in land use planning. I spent some time at the Department of Community Affairs and practicing in Tallahassee. And then I spent about 5 years primarily litigating constitutional and property rights claims against local government and state government agencies. And then I decided I was more interested in helping get things built than clean up the mess afterwards. And so I've been here in Tampa for a while, and my practice now is primarily processing land use and environmental applications and petitions.
And I'm Jessica Iserman. Prior to joining Stearns Weaver late last year, I was the land use attorney for Leon County for the last 5 years. And in the interest of time, I'm going to go ahead and jump in the webinar. So we have seen amid this COVID crisis that virtual meetings are now our new reality. For the first time in history, the Florida Supreme Court is holding oral arguments using remote video teleconferencing, specifically Zoom. And they will be available to the public to view through existing live feed channels. Most court hearings now are also virtual, with witnesses being sworn in virtually too. DOA, the Division of Administrative Hearings, is used to conducting technology hearings. They do that in their regular routine business in any event. So they have some good policies and procedures in place already that local governments can borrow from in terms of providing witness lists and exchanging exhibits ahead of time. Since the governor signed Executive Order 2069, many local governments have quickly transitioned to hosting virtual meetings. or at a minimum allowing virtual participation through email or phone citizen comments. However, while local governments are using technology to continue with government business, many have not held public hearings on land development issues. Some local governments are holding or planning to hold public hearings on quasi-judicial matters, and the ones that we have found are Pasco, Martin, and Orange counties. So before we dig in, I want to give you some background that would be helpful in understanding why virtual hearings present some unique challenges for those seeking land development approvals. Generally, local government actions fall into one of three categories. You'll notice that these mirror the three branches of government. Executive actions are those that are administrative or ministerial in nature. This means that there's no discretion by the local government in taking that action. This includes building permits, addressing. So if you're seeking addressing for your parcel, just simply making that application, receiving that address is an executive action, as well as plats. Typically, plats are considered ministerial in nature, provided you meet the Land Development Code regulations. The second the second type of government action is legislative. This is developing policy or law. This is your standard ordinances, comprehensive plan amendments, even map amendments are considered legislative in nature. Impact and mobility fee ordinances, development agreements, proportionate share agreements. Those are all considered legislative in nature. Finally, the third type of local government action is quasi-judicial, and that is applying policy or law to a specific facts and specifically, a very narrow set of parcels. So this requires the government to hold a hearing, and these hearings are akin to kind of a judicial hearing where the government body is sitting as a judge. Evidence is presented and witnesses may be cross-examined during these hearings. So an example of quasi-judicial includes rezonings, variances, plats, or plat vacations. Also includes maybe special exception permits, liquor permits, and licenses. So what makes quasi-judicial hearings so special is that there are three essential legal requirements that must be met during these hearings. Those are the essential requirements of law, competent substantial evidence, and due process. Briefly looking at the first two criteria, essential requirements of law means that a local government must apply the correct law in making their decision. So for example, if a local government applies the variance criteria to a proposed rezoning, that local government would not be meeting the essential requirements of law. Competent substantial evidence means the evidence relied upon in making the decision is sufficiently relevant and material. Since quasi-judicial hearings require submission and authentication of evidence and testimony, this is an important consideration that we will discuss further and in conjunction with the due process component. So due process requires the right to be heard, the right to notice. It requires an impartial decision maker and basic fairness and cross-examination of witnesses. When compared to normal physical quasi-judicial hearings, there are some unique due process concerns to consider in a virtual hearing. Again, quasi-judicial is akin to a court trial. So in a virtual setting, this can make things a little bit more tricky. So local governments have naturally raised a lot of concerns regarding how to hold quasi-judicial proceedings, which not only has an applicant that gets the right to present evidence and speak, it has members of the public and interested parties that also have a right to present evidence and speak as well. So one of the biggest concerns local governments have raised is technology. This includes insufficient equipment and software, glitches, public participants unknowingly remaining unmuted during their time to speak. Public participants may not have the ability or to participate. Either they don't have the internet or they don't know how to use the technology. And also the creation of and access to an online record. So some solutions that we have identified these concerns is to provide several methods for public comments. Local governments have always allowed members of the public to write or email comments in in advance of public hearing. A local government may adopt more robust policies encouraging collecting and circulating these comments in advance of the hearing. The more methods of public comment, the better suited the public is to have that opportunity to engage. So we encourage local governments to use all available methods. Similar to live public hearings, there will always be obstacles for public participation. Just like live meetings require a person to have transportation or childcare or taking off time from work, a virtual meeting requires some type of internet access or TV access or phone access. We think hybrid meetings, which we'll discuss a little bit further, may be the best option to provide both a physical location for those who do not have internet access, as well as providing internet interactive abilities too for those who can have the ability to stay home. It is also important to note that providing comment in advance of the hearing is not a substitute for participation at the hearing. The local government must allow participation during the hearing. So procedures for handling public participation could include pre-registration of public commenters. This would help streamline the public comment process, and knowing the chairperson can know who the next person is to speak and be prepared with how they are speaking, via phone, via video, or via remote technology through Zoom or other technology. It's important that clear procedures are adopted by local governments and that these procedures are also advertised to the public so everyone is on the same page in what rules we are working with. I think it's also a good idea for a local government to provide a tutorial. So some local governments have a 2 or 3 minute video before their meetings start. I think it'd be a good idea to have a script ready, prepared for that local government to indicate how they're receiving public comment, how you can contribute to public comment during the meeting, whether it's an email address or a phone number. So finally, or another concern is the Florida Sunshine Law. So Executive Order 2069 suspended the quorum requirement, so local governments can meet virtually at this time. I think it's important to note that that executive order is tied to the state of emergency order. So long as the emergency order, I believe it's 2052, is in place, the governments can continue to meet virtually. Under normal circumstances, the Sunshine Law is, it has to be met with the physically present criteria, which is waived at this point. Sunshine Law has 3 basic requirements. The meetings have to be open to the public, they have to have reasonable notice, and minutes must be taken. It's important to note that the Executive Order 2069 did not waive this requirement. Those must continue to be met. There also has to be an opportunity for the public to speak, and ensuring a verbatim record of the proceedings is available if needed down the road. So some of the ways a local government can address these concerns is, again, have as many methods of public comment available, including a physical meeting location that may be able to follow the CDC guidelines regarding social distancing. The notice should also clearly state that the meeting is virtual and provide instructions on how to participate very clearly and well in advance of the meeting. So another concern raised by local governments is providing due process, and for that, I'm going to turn it over to Jake.
Thanks, Jesse. Due process, I think, is the biggest concern that we're hearing, not only from our friends in local government, but also our clients as applicants and members of the public. And I think it's important to remember when we're talking about due process, there's one of the original Florida cases called Metro-Dade County. It's a 1969 Florida Supreme Court case. And that case is really our poll star in understanding what due process rights have to be given. And that case said that the mechanics of how a board gains an understanding of a cause is not particularly important, so long as a competent understanding exists when that board makes a decision. So the Florida Supreme Court has, going back many decades has given local governments flexibility in how they hold these hearings. And the case law as it developed has also drawn a pretty clear distinction between parties and participants. And the distinction there is that a party has to be given more rights. So party is always going to be the local government and the applicant. And they have the ability to present evidence, the ability to cross-examine witnesses, and to be informed of all facts upon which the local government acts. Participants, on the other hand, so these would be members of the public at large, they're generally not afforded the right to cross-examine witnesses. Instead, they have the right to be noticed of a hearing and the right to be present and speak at the hearings. Now, as you might imagine, there's a lot of gray area here, and it's not always clear who's a party and who is a mere participant. Local government codes oftentimes either draw a clear distinction, or sometimes some local governments offer essentially party rights to any member of the public. And what I'm hearing from some friends in local government is that they're looking at this as this challenge as an opportunity to clean up their codes in how they conduct hearings. And I think one thing that can be done for those thinking about that is to look at how can you draw a clear distinction between who's a party and who's a participant up front, ideally before a hearing, because as I think we'll talk about a little bit more, the biggest challenge to any virtual hearing is going to be when someone is surprised. And I know a lot of times as attorneys we like the element of surprise, but I think in a public hearing, a virtual public hearing setting, it's going to be counterproductive. And so to the extent that as the local government you can clearly delineate what rights everyone has going into the hearing, I think that will really be helpful. We're seeing a number of other concerns and things to consider in terms of due process. Some concerns and questions we're hearing are how do you visually identify participants, and do you need to do that when swearing in participants? Questions about qualifying experts, viewing evidence and providing copies for the record, cross-examination of witnesses, and site plan reviews. And by that I mean, even in a physical hearing, it can be challenging to visually identify and talk about a site plan, and then thinking ahead, if there's an appeal, how does that discussion translate? Oftentimes it doesn't translate at all, and from the cold record, you can't understand what anyone was really talking about. And so, for all these things, we have to go to greater efforts and greater lengths for clarity in these virtual hearings. So, to start addressing some of these, we think about, Jesse mentioned, you think about government actions as the three branches of government. And with quasi-judicial hearings, I think we can look at the processes that are being used by our court systems, and also the processes being used by DOA. In my view, if a process is good enough to be used by a court, then it's going to be good enough to be used by a local government, at least technically, or procedurally, excuse me, realizing the technical challenges of making that happen, may be difficult. So, for example, the Florida Supreme Court Administrative Order 2016 provides a process to allow witnesses to be sworn in by notaries remotely through audio-video communications technology, provided that the notary can identify the witness. I'm hearing differing opinions from local governments about whether they feel the notary needs to visually identify the caller or the participant versus just by voice. It seems like to me from the local governments that are moving ahead with these hearings, what I'm hearing the most is that they are having someone verbally, but not necessarily visually, identify those participants ahead of the time that they speak. So maybe before the hearing even starts. And again, keep in mind, going back to Metro-Dade County, going back to the Carillon case, it's always a balancing act. So if you end up in the appeal situation, the local government is going to take into account all of the facts and circumstances at the time of the hearing. So the courts are going to take into account COVID-19. The courts are going to take into account whatever executive orders had been issued at the time of the hearing. And the case law is also pretty clear that the court can consider even whether so if there's an allegation that additional measures could and should have been taken, the courts can consider whether those measures would have been unreasonably burdened or even unreasonably expensive for the local government. So on the local government side, it's a good idea to think about documenting why you're taking the actions that you are. So sort of along with that, you know, and a lot of the local governments we're seeing that are moving forward, finding ways to move forward with hearings are doing this, which is adopt and follow uniform rules for procedure in your virtual meetings. We think deadlines for submission of evidence is something worth considering. You know, there may be circumstances, just as it would be in a court hearing, where evidence comes up at the last minute or it's not able to be shared ahead of time, but we think those cases are probably pretty rare, and that is a requirement to have a deadline to submit evidence for anyone is a good idea, and that will again prevent some of the chaos that makes managing these hearings so difficult. The local governments, many of them are already utilizing screen sharing technology, so everyone that's watching and participating can be aware of the visual aid being discussed. We're seeing this in, I think most local governments have conducted at least one virtual meeting at this point, and that technology can be used. Although there are difficulties, especially in cross-examining witnesses, which we can talk about that a little bit more, those difficulties. We also think it's a good idea for the chairperson at the end of each and every hearing to ask very, very pointedly at the end of a hearing some version of the following. Does anyone feel they have not been heard or afforded due process for any reason? If so, please state your concern on the record to give this body a chance to address it. You know, the case law is pretty clear that, again, just as in a court setting, that body, the decision-making body, needs to be given the first chance to make things right if there's a concern. And we think that by very clearly requesting that information, that the body can then deliberate, make a decision, and then your record is clear, and you've also gone above and beyond being able to allow for due process. You might also consider having a process for after the hearing in case someone has technological difficulties, to be able to submit submit a problem, keeping in mind if you create that process, it could also lead to complexities if the local body decides to take up that question or that problem in a future hearing setting. Adding more hearing dates, this is more of a practicality, but adding more hearing dates to the calendar, we're seeing many jurisdictions already committing to this. You know, look, these hearings take a lot longer. What I'm hearing from my friends on the bench is that virtual hearings take at least twice as long as an average hearing. I think we're expecting that even with simple quasi-judicial hearings, that should be the expectation as well. And so more hearing dates are probably going to be needed on most local government calendars. The next concern we're hearing, and this relates to due process, is the timing of development orders and permits. You know, many local government codes include provisions for hearing timing requirements. For example, that after a hearing is, after an application is deemed complete, you have a certain number of months or to get to your final hearing, or it's automatically withdrawn. And that's posing some problems in some jurisdictions. So we would recommend that both on the local government and the applicant side, that everyone come to a clear understanding, at least get it in writing, request suspensions or tollings of those proceedings if they're necessary, and keep in mind that that may not be something that staff can do administratively. That may be something that the local government as a body needs to take up and issue some sort of emergency order suspending that or ratifying staff actions to be safe. We've had a number of questions from folks that, whether for contractual deadlines or some other reason, absolutely need to move forward as soon as possible. And you know, we've had a lot of questions about the statute that was enacted for municipalities and counties last year in the legislation. Some people are calling it a shot clock. And you know, it's after the application is deemed complete, it says that the local government must approve or approve with conditions or deny the application. And you know, it's interesting because it says it does allow for a force majeure or extraordinary circumstance, but unfortunately, you know, fortunately or unfortunately, depending on which side I guess you're on, it does say that both parties may agree to that reasonable request for an extension of time. And so, you know, there is some question out there about, could a local government force someone to go to hearing, say if there's frustration due to delay, or could a party force the local government to allow a hearing? And you know, those questions haven't really been answered. There's not any case law on this. Most folks are, you know, really negotiating when the appropriate time to go to hearing is, and it may not be practical to try to force the issue on this question because the issue would be, you know, is it helpful if a local government hasn't had hearings for many months, and you get in the situation where you want to force the question? Do you go to court only to get an order that says, yes, thou shalt hold a hearing on this matter? Do you really, as an applicant, want to be in that situation? So practically speaking, this statute may not be helpful to anyone in this statute, but it is something that we should consider, especially if we're in a scenario where 3 or 4 months from now, for whatever reason, physical hearings just, you know, still are not possible. You know, we're getting a lot of questions overall on these, and so at some point, I think, you know, the question is this: local governments are going to need to hear and decide land development applications. Some of them are going to be much easier than others. Plats, development agreements, those kinds of contracts are going to be easier, even if a public hearing needs to be held, because they're not held to the same high bar as a quasi-judicial hearing. And you know, we've already had questions from frustrated applicants. You know, are there any property rights theories or constitutional theories to allow us to move forward? And you know, we think the courts are going to allow local governments, you know, pretty wide latitude in terms of making these decisions. I think it's very difficult in a situation like this to say that there's been a temporary taking or a denial of due process or a denial of your First Amendment right to petition the government, at least until we get to, you know, 5, 6 or more months of delay. I don't think we're going to be seeing delays of that length, but at that point, if we get that far, then local governments really need to have figured out a way to make virtual hearings happen. And risks, the risks to include, I think, and I guess Elise is going to be talking a lot about this. The applicants really need to consider the risks of moving forward where it's an opportunity versus the risks of waiting. A lot of times this is going to be a business decision. And, so with that in mind, Elise, I'll turn it over to you and so you can discuss some of the practical considerations.
Sure, of course. We wanted to finish up our part of the presentation by talking to you all about what we think are best practices. We've spent a lot of time sort of assessing this, looking at local governments throughout the state of Florida, and just taking our collective knowledge to try to put forth best practices, mostly for the applicant, but also for local governments, and then some things that we should all think about. The first thing, of course, is understanding the risks. As Jake said, there are risks to any virtual hearing. Anytime you do something new, this is a little bit like the wild, wild west. We're all figuring this out together. So you have to understand that if you're going into a jurisdiction that is permitted virtual hearings to move forward, it's as much on the applicant to know their rights and to know what the risks are and to even try to cure those within the hearing as it is on the local government. So there are lots that you can do as well. The first risk, of course, is the risk of litigation. Because we don't have a lot of case law talking about virtual hearings, this is new to everyone, an opponent can always come in and try to make the argument in court that they weren't afforded due process, as we've discussed. But if it's done properly, we believe that these challenges can be addressed. One of the things that you may not think about as a risk is a risk of, this loss of advantage. Normally, we go to a hearing and we present our materials at the hearing for the first time. Many jurisdictions that are moving forward with virtual hearings are asking that documentation be submitted ahead of time. Of course, that makes sense in a virtual hearing world so that everybody has the opportunity to see that information. But it does change your advantage a bit. Normally we may not submit certain documentation as an applicant unless someone objects to that point. So you have to think a little bit more strategically, and you have to think about the graphics that you may need, materials that likely will need it to be submitted in advance. And you need to think about that, doing that at a much earlier period so that you have time to think through all of the potential logistics on how that information gets into the record. So you're going to take more time, but I'd suggest doing one thing, and if I can give you one tip as an applicant, it would be this. I suggest that you read materials into the record more than you normally would. Personally, I do a lot of chatting, right, when I'm at a public hearing. I interact with the commissioners and I talk, or city councilmen, and I talk about issues that they bring up. But it's really important that if you have, for example, a visual, that you try to verbally describe that in a virtual situation in case someone is not seeing that information clearly. In the case of a regular hearing, you can point to things, but you have an extra burden to make sure that you verbally describe things. This may also mean that you need to ask for an extended period of time to give your presentation, but I think that local governments will be open to that given, the crisis that we're in. The second point is to understand technology and understand it well. One of the things that we found is that the local governments that are holding virtual hearings, whether they're executive, whether they're legislative, and that handful that is actually moving forward with quasi-judicial, all of the platforms are different. And so as an applicant, or as someone who's objecting, or as a local government, we all need to spend extra time understanding the technology before the hearing. I suggest that you test the technology if you're submitting documentation and you want to be able to present evidence and testimony, that you get in touch with the local IT person at the local government and you actually have that resource. You run through, maybe even do a test of whether you can submit evidence properly. So it's also going to be important for the local government and their IT staff to have those resources available for people that want to do that, because I think that's going to make it much cleaner. It's going to resolve a lot of the technology glitches that we're concerned about. It's also a good idea, if the technology permits it, to share your screen if possible. This might not always be the case. In fact, I was watching a hearing last night that they're doing in Orange County. We'll talk a little bit more about how they're handling hearings. And an attorney was presenting like I am here. And if you can see me in the little box, they were actually just holding up material and pointing to the screen. This works. You know, maybe it's not ideal, like if we were in a physical setting, but it actually works and you can convey that information. So think about innovative ways to convey that information if you cannot share your screen. It's also important, particularly if the local government or the applicant thinks that there might be opposition, to make sure that there is a verbatim transcript available. If you're an applicant, that means having a court reporter. There are court reporters that have more experience with virtual technology than others. So we would strongly suggest that you really spend time determining which court reporter has that experience and have them come and be the court reporter. Again, they're going to have to work with IT and the local government, but that is an option and that should be made available. It's also perfectly acceptable and advisable that if you are an applicant, or you're part of the local government, or you're someone that's opposing an application, if you see issues that come up with due process, speak up. If I'm an applicant and, for example, someone during opposition testimony didn't properly give their name or their address in a way that it could be that it can be heard, go ahead and bring that up tactfully and help, as a housekeeping matter, fix those things on the record. I think that we all have to take responsibility to make sure that we're thinking about these things in hearings, and that we all work together to make sure that these due process issues are addressed. Excuse me. One of the things that certain jurisdictions have done is, Pasco County in particular, they're asking applicants to waive their rights to cross-examine witnesses. Now, cross-examination of witnesses isn't something that we often do in quasi-judicial hearings. If you haven't seen that many hearings, you may not have seen it, but it does happen from time to time. So let me give you an example if you're not familiar. If I'm an applicant and someone comes in and, let's say, for example, they bring information or they testify about something in opposition to something that I'm trying to get approved, I have the right to ask them questions on the record. That's cross-examination. That is available to the applicant. And so while you don't often have to use cross-examination in quasi-judicial hearings, it is a right that you're afforded. So it's really critical that you understand what it means if you're waiving that right. There are times, for example, if you don't feel comfortable waiving that right to cross-examination, then you're really going to have to balance the business decision on whether you want to wait for an in-person hearing or whether you need to go forward in a virtual setting. It's really just about understanding the risks and making that business decision. Remember, in all of these situations, if things take a turn for the worst, you can always ask for a continuance. So if you are not getting the ability to cross-examine, for example, and you need to cross-examine, it's perfectly acceptable to ask for a continuance. And I think in this particular situation, local governments are going to be more apt to grant continuances because of the virtual environment. The other thing that I want to talk just a little bit about, and then we're going to take some questions, is the early resolution of issues. You know, in a normal hearing, there's all kinds of sidebars that go on. For example, the applicant can talk to their attorney or their engineer or their planner. Folks that are from the opposition can talk together about things that you can say. we can talk with the county attorney about issues as they happen. In a purely virtual world, you're not able to have those sidebars. So more than ever, working through those issues prior to a hearing is really imperative, if at all possible. Make those phone calls ahead of time. Try to get your issues resolved as much as possible so that any issues that come on during the record can be addressed, and they can be addressed clearly. Remember, your strategy, regardless of who you are, your strategy is very different in a virtual context. You want to try to minimize the risk of any kind of lawsuit and maximize your chances of approval if you're an applicant. And if you're a local government, you want to keep any kind of lawsuits later to a minimum. So again, think about these best practices as we move forward. One of the things that I did want to note that's come up, and I think Jake briefly mentioned it, is that Executive Order 20-69, which is the order allowing local government meetings to happen via technology, it expires upon the expiration of 20-52, another executive order. At this time, that executive order is set to expire on May 8th. While our Tallahassee colleagues expect this order to be extended, it's really important that we all watch this to ensure that these virtual meetings can continue past May 8th. So I just wanted to put that on your radar. And then finally, I want to present one thing which I think will be very interesting to talk about during questions, and that is the hybrid approach. I watched a hearing yesterday. Orange County had their first quasi-judicial virtual hearing. And what they did is they had all of the board members attend virtually. But in the county center, there was a virtual stand with all of the virtual technology. So if you wanted to participate, regardless of who you were, there was the option for you to do that. You automatically get rid of technology glitches because the local government is running it. And if there is a glitch in technology, that local government IT person can pause the meeting for a moment and fix the glitch. So that eliminates a lot. It eliminates the issue with swearing in witnesses, because you could have those witnesses sworn in at that station. It just seems to be, in our opinion, one of the better approaches, having a combination of virtual and the ability to physically be at a hearing location or a virtual station to present evidence and to present testimony. As far as local governments go, a couple of best practices are really, we think, submitting the evidence ahead of time. It's going to change the way that we all work, but I think it's probably very even and very fair. Provide an accessible means for public comment. These virtual stands, these virtual IT stations could be a really great way to move forward with virtual hearings and cure a lot of these due process concerns. And finally, I would say just keep it simple. The more different options you have, the harder it becomes. So if we keep it simple and the instructions are very clear and they're sent out far in advance of meetings, I think that we can all figure out a way to move forward with these hearings together. With that, we want to hear what you guys have to say. It looks like we have a lot of questions, so I'm going to turn it back over to Jessica to start pulling questions, and then we'll start answering your questions. Thank you so much for all of the questions.
So Jake, I'm going to start with you. We've received a lot of questions regarding swearing in of witnesses remotely. Specifically, what about administering oaths in virtual quasi-judicial hearings? And my understanding is that there is a Supreme Court order that allows the virtual swearing in of witnesses, provided the notary can see the witness through video, audio technology. Do you have anything more to add about those concerns that have been raised?
Sure. So again, I think this goes back to, remember I mentioned the Metro-Dade County case, which explains that the way a local government gets to its decision is not particularly important, as long as they're coming to a competent understanding of the issues. So I think the first thing local governments should be doing is, again, delineating between who is a party and who is a participant, because that determines how much due process is needed to that individual. I think the other thing to keep in mind is that, think about how we generally swear people in your normal land use hearing process that we never hear complaints about, right? In the beginning of a hearing, the clerk stands up, asks for, does a cattle call, asks for everyone to raise their right hand, and then it's sort of on, gentleman's honor, whether you've given the oath when you stand up at the podium. Some local governments are a little more cautious, and they do ask people to restate that they've been sworn in. But that's all. We don't have any intense questioning of participants or even parties. We don't ask for their driver's license. So we use a very informal process already. And so when we translate that to the virtual setting, I do think it's a good idea to formalize the process a little more, so that if there is a challenge later, that can be explained to the court of, here are the steps we took to make sure this person is who they say they are. My personal opinion is I don't think you need to go to the length of having visual identification. I think it is a very good idea to have a clerk or someone designated to call people, and before they speak, find out who they are and what their address is, like we would do in a normal hearing, but to do that individually rather than in some sort of a cattle call, because a virtual mass swearing in just really isn't possible. You can't even visually identify like you would in a hearing if people are standing up. So those would be my recommendations.
Great, thank you, Jake. We have a question from my former colleague, Ms. Susan Poplin. If one medium, i.e. a dedicated phone line, works well and gives all the opportunity to speak, would that be okay? In my opinion, we also need to provide participants and members of the public the right to present evidence, and the phone line doesn't do that. So there also needs to be an added medium to allow that exchange of documents in addition to the public testimony. Elise, do you have anything to add to that?
No, I agree with that. One of the things I want to add is, if you think about a regular hearing, there are often times when people cannot physically get down to the hearing. So they communicate via email, they provide written letters. All of those still exist. So as long as you have some opportunity to present evidence for those who want, just because people can't physically get there, it's no different than if I, am working second shift and I don't have the means. There are other ways, and we now have various ways to communicate and submit documentation into the record, and that will remain in virtual hearings. So I think we have to remember that the opportunity has to be there to participate. It's not a right for every single person to be able to participate all of the time. There are plenty of people that don't have the time or the means, and they get that information to the local government in another way. And we're really just in the same situation with different facts in a virtual world.
And Elise, I'm
right.
Sure that... Go ahead, Jake, I apologize.
Thanks. Just to add to that, I see a similar question that Tampa Councilman John Dingfelder asked. Thanks for the question, Councilman. And the point he brings up is thinking through, especially what if we have people that are part of a sensitive population and they express this concern, how do you give them the opportunity? And I agree with Elise. It might be a different scenario if we have someone who has who has shown health risks and they're a true party in interest. So they've upfront established to the local government that they have substantial interests that are going to be affected. And then I think the local government should really be taking that, working with the applicant and this third party. Look, that may be a case where legitimately you cannot move forward because you can't afford this person due process under the circumstances. And there are going to be cases like that. In many cases, I think there will be a way to move forward, but certainly not all of them.
Absolutely. I'm drawing a blank on which jurisdiction it is, but they provide all of the comment coming in from anyone except for the applicant. You provide documentation 72 hours in advance, and they read it into the record for you. So there are lots of opportunities to make sure that documentation and testimony can get into the record appropriately. We just need to make sure that we're being sensitive to all of those different situations and thinking, how can we get this information into the record appropriately? But I do think there are options for us.
So Elise, can you elaborate on the idea of virtual stations for swearing in terms of how to deal with social distancing?
Yes, so we watched Orange County, all three of us, I think, yesterday in the first virtual hearing, and we had actually come up with this idea of, we're calling them sanitary stations, right? They're virtual stations where all of the technology is already set up for members of the public to participate. And from what I could see, there were people there that people social distance appropriately. You don't touch anything. You just come up to a camera on a laptop and you're able to provide testimony. You're able to turn your documents around, if you can see me, and point to different information. And this actually allows you to adhere to social distancing. It removes the issues with glitches, and I think it's a really good option. This would be a station that would be provided by the local government, and obviously where the location of that station would have to be in the notice that was sent about the hearing so that everybody knows where they can go. But it does solve a lot of the issues, and I think it, as long as you have someone there that's making sure people are appropriately social distance, you could put X's on the floor, and I think it can be done effectively.
Mm-hmm. We got a question, how do the executive orders relate to virtual inspections? I believe that's in terms of building inspections. In my opinion, they do not impact building inspections. The executive order we're talking about just relates to the quorum requirement for local governments. Virtual inspections is a new animal that it doesn't have a legal basis, just a public health, safety, welfare basis, provided, inspections can continue. They can be done in any form, to my knowledge. We got a lengthy question. There is some risk to the local government in having the chairman ask if anyone believes they have not had a fair opportunity to present their case or comments. The question invites participants to attack the local government procedures as potentially defective, with little ability of the local government to fix the issue. For example, a participant party complains that the 3 minutes per participant or 15 minutes for the applicant to present their case is insufficient. Jake, would you like to respond to that?
Sure. So I think that's a great point. I don't think, I think, my suggestion is going to be difficult to implement if you don't have a strong chairperson or an attorney for that board who's willing to step in and help guide the conversation. I think that's where the attorneys really need to be advocates for their boards. And, this could be an opportunity, again, for local governments to clean up their codes where procedures aren't clear. I think there will be some chaotic questions occasionally, but if the local government attorney is able to guide the discussion of the board, focus them on, have the requirements of your code been met? And then is there anything about this circumstance that's unusual enough that we should deviate from the code? And then the board has a thoughtful deliberation. Then I think that will satisfy the test, whether or not they give that person additional time. I don't think courts are going to go very far into armchair quarterbacking those decisions. But I do think the additional time it takes to talk that out and think it through is going to be worth it. And, I think that, this sort of gets into some of the discussions about this isn't going to work for every case. In some cases, we're going to find complications that we all know in land use hearings. Sometimes we think we have a very simple issue, a simple case to present, and 2 hours into it, we're still not done. If you end up in that kind of a scenario, everybody should be thinking about continuing, because it's not really going to be to anyone's advantage to try to take advantage of that situation and have a well-reasoned discussion. Elise, as our time is winding down, one thing I've been thinking about, I know you have a couple of cases you're working on this. A question for you is, how are you thinking through having a community meeting in a scenario like this? Obviously, right now, with the stay-at-home order, I think it's a no-brainer that we shouldn't be having community meetings in general. Maybe there's a purely virtual scenario, but let's say the stay-at-home order is lifted, but we still have a state of emergency and we're still observing social distancing. What are you thinking in terms of how could you have an effective community meeting in that situation?
Well, this is a really good forum, this go-to meeting. One of the things that we are thinking about, we have a neighborhood meeting that needs to come up before hearings go back. And initially, our thought was we would address things in like a go-to meeting situation where we provided notice to all the surrounding neighbors and they could send us questions ahead of time and we would address them. And then there would be an opportunity on that go-to meeting or Zoom meeting for everyone to speak and participate. I think, even after everything is lifted, there are going to be folks that aren't comfortable coming into crowds. And so, again, this hybrid situation of a community meeting could work very well too, where you are here with technology. You have technology available for the community meeting, but you also have the ability for people to come in and and have proper distance separation requirements. The key is, I think, for anyone that's hosting a public meeting is to make sure that the instructions are clear. Again, keep it simple. Make sure that people have advance notice of how they can participate, whether it's one way or whether there's another way. And again, local government's codes do not contemplate this. So there is going to have to be some leeway in trying to create these virtual meetings. And if that means that, local governments say, hey, in this situation, we need to amend our code during this period of time, then that may be a way that we have to address it. But we have come up with a lot of different ways to hold neighborhood meetings. And I think that they work really well because as long as we can present information and then we can answer questions, I think you're getting an effective dialogue.
So we have several more questions, but in the interest of time, I'm going to suggest that if you still have questions that were not answered, please email one of us or all of us, and we'll be happy to answer your questions. I see some people have also requested a copy of the presentation. We can go ahead if you would like a copy. If you email us, we can send you a copy or an outline of the presentation so you can refer to the material at a future time.
And I think just to sort of wrap up too, please, we have your information. So if there are substantive questions we haven't answered, one of the three of us will try to email you, and then you can call us if you like. But our purpose in putting all of this together with local governments, lawyers, applicants, people from the industry, community activists, is really to make sure that every jurisdiction has a plan B if we need it. If the COVID crisis continues, or if we have a resurgence at some time in the fall or the winter, we are really going to need things to be moving along in our economy, with unemployment as it is. It's imperative for all of us to take responsibility and try to get together and continue this dialogue about what is our plan B. So I encourage you all to continue to talk to us, continue to talk to one another, because I think that this is something that's very doable if we put enough energy into it. So Thank you very much for your time. Jake, do you have anything else you want to say before we wrap up?
No, that was a great wrap up, Elise. I appreciate everybody joining, and hopefully we've sort of helped move along the statewide conversation. I think to those in government, use us as a resource, use your local land use bar as a resource, because at the end of the day, we're all moving towards the common goal of building our communities, and we hope this has helped further that conversation.
Great. Thank you, everyone.
Thank you, everyone. We look forward to talking to you.